We're told that when you see something wrong in government, you report it. You gather the evidence, you file the complaint, you let the system work. But what if the system is designed to stop you before it ever looks at your evidence? What if the rules meant to hold public officials accountable are, by design, nearly impossible for an ordinary citizen to satisfy? Today, we're examining a real case from Citrus County, Florida, a case that exposes a structural flaw baked into Florida's ethics process for more than 40 years, a flaw that allows a well-documented complaint to be thrown out without a single fact being investigated. July 8th, 2025, Citrus County, Florida. The Board of County Commissioners had been in session since 1 in the afternoon. By the time the final vote was called, it was nearly 11 o'clock at night. The item before them, Tuscany Ranch, a proposed development of approximately 5,000 dwelling units. Commissioner Rebecca Bays, serving as the 2025 chair of the board, voted yes. The motion passed 3-2. What happened next, or rather, what did not happen, is the subject of this story. Under Florida law, specifically Section 112.31433A of the Florida statutes, a county commissioner who has a special private interest in a vote must do two things. First, before the vote is taken, they must publicly announce the conflict. Second, within 15 days of the vote, they must file a Form B, a memorandum of voting conflict, with the county clerk. In April 2026, a citizen filed a public records request with the Citrus County Clerk's office. The response was direct. Amy Novinger, a clerk's office representative, confirmed in writing, there are no Form 8Bs on file for July 2025. No announcement, no form, nothing. The citizen who filed the complaint didn't rely on rumor or speculation. She assembled a documented record from public sources. Meeting minutes confirmed that Commissioner Bays voted in favor of Tuscany Ranch on July 8, 2025. Florida Department of State records showed that a company called Alta Terra LLC listed Michael D. Bays, the commissioner's husband, as one of its two managers. Citrus County property appraiser records show that Alta Terra LLC owns a strip mall at 750 West Hampshire Boulevard in Beverly Hills, Florida. And a separate property record confirmed that Michael D. Bays and Rebecca K. Bays were listed as husband and wife. That strip mall sits at the intersection of Lecanto Highway and West Hampshire Boulevard, one of the primary entrance corridors to the proposed Tuscany Ranch development. The complaint included photographs, an aerial view, a street-level image with handwritten labels pointing to the strip mall and the direction of the new development. 6 exhibits, all from public records, all attached to the complaint. The legal theory was straightforward. If a 5,000-unit development is built and the main entrance runs directly past your husband's strip mall, that property stands to gain from traffic, from visibility, from commercial demand. Florida law says a public officer cannot vote on a matter that would inure to the special private gain or loss of a relative. A spouse qualifies. An LLC managed by that spouse qualifies. The complaint argued that Commissioner Bays had a duty to disclose his potential conflict and to abstain from the vote. She didn't either. On June 5, 2026, the Florida Commission on Ethics met in executive session. They reviewed the complaint for what is called legal sufficiency, a threshold review that asks only whether the complaint on its face could constitute a violation of the ethics code. The Commission's own order stated this plainly. No factual investigation preceded the review, and therefore the Commission's conclusions do not reflect on the accuracy of the allegations of the complaint. Read that again. The Commission explicitly said its conclusions do not reflect on whether the allegations are accurate. They weren't deciding whether the commissioner did anything wrong. They were deciding whether the complaint cleared a procedural bar before any investigation began. It did not clear that bar. The complaint was dismissed. The commission's reasoning turned on a single phrase, too remote and speculative. The order cited a line of prior commission opinions stretching back to 1985. In each of those cases, the commission had ruled that when a development is merely located near a business owned by an official or the official's relative, any resulting gain is too indirect to count as a special private gain under the statute. Applied here, the commission concluded that there was nothing in the complaint to suggest the Tuscany Ranch development was certain to affect the strip mall's value beyond the citizens' claim that it would stand to make a tremendous gain, which the commission called conclusory. In other words, the citizen had to prove at the very first step before any investigation that the financial gain was concrete and certain. Not possible, not plausible, certain. Here is the structural problem. To prove that a gain is not speculative, you would need evidence of what the development will actually do to nearby property values. You would need appraisals, financial projections, developer communications, or expert analysis. A private citizen has no subpoena power, no discovery tools, no ability to compel the production of financial documents. Yet the commission's legal sufficiency screen, the very first gate in the process, requires something close to that level of proof before it will even agree to investigate. The citizen gathered everything available from public records, meeting minutes, corporate filings, property records, photographs, a clerk's confirmation that no disclosure form existed. And still the complaint was dismissed. Not because the facts were wrong. The commission said it wasn't even looking at whether the facts were right. The commission's dismissal order was not a new interpretation. It was the application of a doctrine that has been in place since at least 1985. For more than 4 decades, the commission has held that proximity-based gain, the idea that a nearby business benefits from a development, is too remote and speculative to trigger the voting conflict statute. This doctrine has been applied across party lines, across jurisdictions, across different types of officials, and different types of developments. That consistency is important. It means the story here is not about bias towards one official or one party. The story is about the doctrine itself. The rule, as written and applied, makes it structurally difficult for any citizen to successfully challenge a vote where the conflict runs through a nearby property rather than a direct financial transaction. The rule is the cover. Not because anyone designed it that way with bad intent, but because that is what it does in practice. The citizen who filed this complaint did what the system asked citizens to do. She gathered the evidence, she identified the statute, she documented the missing disclosure, she submitted it all in a formal complaint. The system's response was to dismiss it without investigation, citing a standard that demands proof no private citizen has the tools to produce. That is not a failure of this one complaint. That is a design question. If the legal sufficiency screen requires evidence that only an investigation can produce, and the investigation only begins after the screen is passed, then the screen is not a filter for weak complaints. It is a wall. The strongest story here is not that one official escaped accountability. The strongest story is that the process itself, as it has operated for 40 years, makes accountability nearly impossible to reach when the alleged conflict runs through a nearby property. A citizen has to prove special gain with evidence that requires investigative powers they don't have. The commission's review at the sufficiency stage doesn't investigate anything. And the doctrine that justifies dismissal has been applied consistently enough that it functions as a structural barrier rather than a case-by-case judgment. This case is Exhibit A. A string of prior opinions is Exhibit B. The question worth asking, the question this case puts on the table, is whether Florida's ethics process should require citizens to clear a bar that only investigators can reach before any investigation begins. That is a question for the public, for the legislature, and for journalists willing to follow the paper trail. Rebecca Bay's next ethics complaint comes in the near future. Don't forget to like, subscribe, and share. Join the private group to get the receipts and private training. Yes, we will teach you the methods used to expose these criminals and to hold them accountable. Hit the support button on my profile and bring your questions.